Let's take a look in my remaining 10 minutes on the other justices. Justice Breyer, I think he's in many ways the most discussable of all of the others. He is the Kennedy of the left-hand side of the court. Just as Justice Kennedy is closest to the left, Justice Breyer is closest to the right. That's noted by the very limited concurrence he gave in the funeral case, the fact that he dissented from finding a First Amendment violation in the video games case, and he also dissented in the campaign spending case. That was totally predictable because all of the other liberals dissented in that case as well. But one other case I'd like to take a minute or two talking about. It has some significance. It's called Sorrell against IMS Health Incorporated, and Justice Breyer dissented in this case, which found a First Amendment violation that protected pharmacies from selling the names of doctors on prescriptions to drug companies. If you think about that for a minute, that's something that the other drug companies would like to know, or drug companies would like to know about. What kind of drugs is this doctor prescribing? You know, when they sent around those representatives to office, they know what to tell the doctor. All right, so then they held that was a 6-3 decision saying that Vermont's prohibition violated the First Amendment. Who wrote the decision? Guess, Justice Kennedy, in favor of the First Amendment. He was joined by the 4 conservatives, so you know that's a basically conservative decision. But he got another vote, Justice Sotomayor. Talk about her a little later. Why is it a significant case? Well, it suggests that the conservative majority, in my judgment, is very close to raising the First Amendment standard for commercial speech, almost to the point of saying it gives commercial speech the same protection as all other kinds of speech. For some of the, I don't see too many of those old-timers here, but when I first started, commercial speech wasn't protected at all. It was like obscenity. When I taught it back in the 60s. This court gradually has come up, you know, saying it's somewhat protected, less protected. I think they're very close to putting it all the way up to the top. No, another conservative liberal flip-flop, right? Here are the 5 conservatives voting in favor of free speech, 3 of the 4 liberals voting against it. Why? It's an economic case. I mean, it involved a company, commercial advertising, and so forth. Justice Breyer dissented, right? With Justices Ginsburg and Kagan. I said only Sotomayor went along. And Justice Breyer and Justice Alito, it seems to me, they rival each other as the weakest supporters of the First Amendment. One liberal, one conservative. What distinguishes Justice Kennedy even more, I would say, is, Justice Breyer, excuse me, even more, is he's the most pragmatic justice on the Supreme Court. He is, it's evidenced by that Confrontation Clause case. You know, he's a pragmatist, not a purist. There was another big case for the criminal bar people here called Apprendi against New Jersey about, a dozen years ago. That was a big flap in which the court held that in a criminal sentencing, any fact on which the sentence is dependent, all right, is subject to being decided by a jury. You know, it's to hear witnesses and so forth. Whereas judges, federal judges, and state judges too, used to get a sentencing report, all kinds of facts, right? I was arrested 20 times, or what have you, the drugs that he found. They also found a gun with him, even though they never tried that. They didn't try him for the gun violation. They tried him only for the drugs. Anyway, they said, look, if it lengthens the sentence, then you're entitled to a jury trial. Those were the purists versus the pragmatists, same kind of split. Justice Breyer is the pragmatist, and he has the strongest inclination, especially in the First Amendment, but criminal procedure cases also, and just generally, to balance the interests, you know, and make his own, very much like Justice O'Connor, his own somewhat unpredictable. I don't mean that in a critical fashion, so much as simply a descriptive fashion. It's very often, just like it was with her, very difficult to figure out how they're going to come out because they're so narrow. They do it on the particular facts of the case. They're balancing the interests. They are in many ways, trying to do, at least what in their judgment is the right thing in a particular situation. So a few words about Chief Justice Roberts. He strongly favors narrow decisions. He tends to emphasize the facts in particular cases. The military funeral case, he did that. The violent video case, he did as well. He struck down the statute, voted to strike it down, but only on the grounds that it was a bad statute, void for vagueness. Fix it up, he leaves that question open. He doesn't like broad or clear doctrine, except when he feels very strongly about it, as he did in the Citizens United case, overturning the long-standing understood prohibition, and recently so held by the Supreme Court before that, that neither corporations nor unions had any First Amendment right to spend or contribute to campaign funds. Chief Justice Roberts also, I think, is a very strong favorer of a limited role for the federal courts. He did so in several cases. Last term, one got some play in which he said state taxpayers have no standing. Taxpayers have no standing in federal court to challenge a tax credit. They can challenge a tax expenditure. Excuse me. They can challenge an expenditure, but not a tax credit. Yeah, I think most of the realists would say, what the devil is the difference? I mean, they're getting federal money. In one case, they get the check. In the other case, they reduce their income tax returns. He said no standing in trying to show aid to religion. Trying to show that you've been injured in violation of the Establishment Clause. And he overruled. He didn't overrule, but he ignored a number of prior cases. He also, finally, likes to avoid dissenting. All right? He likes to be in a majority. Chief Justice Rehnquist tended to be that way, particularly later in his tenure. He's second only to Kennedy in being in the majority. And I would put him closest to Kennedy, although a couple of notches from him on the conservative side. He can be pulled over occasionally. Justice Elena Kagan, look, it's really hard to say. One, what I would call partial, almost half-term, because she was recused in so many cases. She recused herself in the first term. But I would say, and I guess my, whatever, I don't want to brag about the predictions. I never tell the ones that don't come out. But he's pretty clearly in the liberal camp. She is pretty clearly in the liberal camp. Probably, I would say, the second most liberal to Justice Ginsburg. Why? Two biting dissents in the tax credit spending case that I talked about and the Arizona campaign finance case. But, there's always a but with this. You shouldn't go away from here thinking that I've said, well, that they're totally consistent. Even Kennedy on First Amendment cases is not totally consistent. Maybe none of us are totally consistent. But there was a relatively significant Fourth Amendment exclusionary rule case, which had to do whether a new interpretation of the exclusionary rule, because an old case was overruled, whether that could be used as a ground to get out retroactive application. And the doctrine was yes, but he said, well, in a case in which the Fourth Amendment rule was the violation, in a now overruled case, it's no longer a violation, right? But if it was a good faith violation by the police, then it doesn't have any retroactive application, even to cases presently pending an appeal. Okay. That is Justice Kagan. Justice Sotomayor, well, she's based on two terms. I think she's, somewhat easier to, Yogi Berra was famous on predictions. He said they're very difficult. He said, especially when they involve the future. So she is in the liberal camp, but I think she's just to the right, to the left, if you will, of Justice Breyer. She joined, for example, the conservatives in the drug prescription case, finding a First Amendment protection for commercial speech. And I think she rivals Justice Breyer in qualifying the scope of her rulings. Very often, she'll write a concurring opinion, as she did in that Fourth Amendment, the application of the Fourth Amendment violation retroactively, and as she did in the Bullcoming, the confrontation case. She joined with the liberal dissenters, but she very carefully laid out facts that she thought influenced the decision again, leaving herself open. She emphasizes factors that were not decided in this case, important ones, especially to her. And we had two final ones. Justice Clarence Thomas, a very interesting justice. He is the strongest adherent, even more so than Justice Scalia, to the original understanding. I'll give you a really strong example from last term. The violent video games case, all right? He has been very protective of the First Amendment, freedom of speech, as applied to commercial speech. But nonetheless, he said there was no violation of the First Amendment in the violent video games case. Why? It was really quite simple for him. He said the original understanding, back in the 18th century, was that kids didn't have any constitutional rights. So that's the end of it. And so that was the end of the case. Now, it was simple, but that is his position. And he spent some time demonstrating why they did not. Finally, Justice Ginsburg is the most, I think now, the most reliable liberal. She's the one farthest to the left, although the fact of the matter is that it is not. The four liberals are not as four liberals have been as liberal as the four have been traditionally in the last 40+ years. For example, before the retirements of first Justice Souter and second Justice Stevens, who was the warhorse for the liberals. I would say she was only the third in the line of liberals. Now she's the most. I want to say one other thing before I give you some time for questions. My final point. Many media reports repeat the thing that this is a, quote, pro-business court. You see that a lot. And there surely is evidence to support this particular contention. The class action cases are and they were big cases. I guess, again, not for me, they're not constitutional cases, but in terms of play and significance, they were the biggest cases of the term. They're the prime example of pro-business. The video games case was another. The campaign spending cases are strong. In fact, although that's not altogether clear. They're seen as favoring corporations. They do favor corporations, but they favor profit and not-for-profit corporations, including labor unions. And one thing, I think the results aren't in. You can't say who the winner is yet in that until we see more evidence of just who's spending how much in these campaigns. Because the fact of the matter is, I believe is true, is that while corporations do tend to favor conservative causes over liberal ones, they're protecting their interests and usually giving money to both parties. I mean, that's true all the time. Not the labor unions. They're pretty consistent in favoring the Democrats. Okay. So the video games case, campaign spending, and the commercial speech cases and others are supported. But there are some contrary decisions as well. The prime example of a big case being a case from Arizona, which is a precursor of the immigration case coming up to the Supreme Court. Arizona it was called Chamber of Commerce against Whiting, in which a federal law which barred the hiring of unauthorized aliens, we're all familiar with that proposition, does not preempt or occupy a field, and it upheld an Arizona statute which further penalized employers who hire such employees. It said that's not inconsistent with the federal law, and the federal government, the Congress did not intend to occupy the entire field. That was a 5-3 usual split. Justice Kagan was out because she had been participating in the case. But that was a conservative decision, given the split of the court anyway, and that was certainly not a pro-business case. They upheld the regulations of the businesses. I could give you 5 more, but I don't think you need them. So I guess as I was told to talk for about 50 minutes, and I guess that you were, your assignment was to listen. So I hope we finished about the same time. And,